Good day, everyone. I'm Ching, SUKD 1800871. This presentation is about the industrial case of Marijuana and British American Tobacco Malaysia Berhad. The content of today's are summary of the case discussions, and the recommendation to the company. Now we are going to talk about the summary of the case. In this case, Mariana binti Hassan was terminated from British American Tobacco Malaysia Berhad according to this personal case. Ms. Mariana was terminated by the corporations in early 2001, but she believed that she has been terminated unfairly, so she sued the company. From 1990 to 2001, the claimant worked for this company for 10 years. Help desk service are the claimant's department. The company decided to outsource this service in 2001. Thus, the claimant was offered a voluntary separation plan and employment separation plan and a 3-month work contract. Her employment at this help desk has been eliminated, she was told. She was urged to accept VSS offer and resign from her work. She would be fired without pay if she refused, and she would not be offered another 3 months of work. On the subject of termination, the claimant was directed to the IT conference room on February 22nd, 2001, where she signed VSS. Therefore, end of her employment on February 28, 2001. The company told the claimant in a letter dated to February 22nd, 2001, that the claimant has surpassed the company's operations demands due to the restructuring of the company IT department. As a result, the claimant had the option of select the VSS plan. She was also promised that she would receive service compensation if she accepted the offer. On the same date, the claimant signed the acceptance form and accept VSS. At the same time, the claimant states that the corporation validates her VSS acceptance, indicating that her last day of employment was February 28, 2001. The company have no proofs in its personal dispute that it has taken any step to retain or transfer the claimants to other areas, or that the claimants have been given notice of her layoff as soon as feasible so that she may find another work. The claimant suffers pain and humiliations as a result of the company's termination. Downsizing occurs in this instance as a result of outsourcing, which recognizes the necessary of the claimant's service and outsource them to independent contractors. Finally, in this case, the claimant was compensated. Because the claimant's position no longer exists, reinstatement is not a suitable remedy. The court trials companies must give up to 24 months of unpaid wages during the claimant's employment and compensate at the rate of 1 month's salary for each year for the service complete. The compensation paid to the claimants will be reduced by the court as fairness and consistency will not allow the claimants to gain twice. The claimants were also paid in accordance with the provisions of her work contract. Next, we are going to discuss about this case. According to the case, on February 22nd, 2001, the COW1 commenced the claimants into the IT conference room to inform her of her termination. For the termination, the claimant has 3 options: VSS, employment separation arrangement, or the 3 months of work opportunity. The company's wrongdoing here is terminating the contract without notice. On February 22nd, 2001, the employer told the claimant that her last day at the company would be February 28, 2001. This is in violation of the Employment Act termination notifications requirement. According to the Section 12 of the Employment Act of 1995 state that either party to a service contract can send to other parties a notice of the intent to cancel the contract at any time. Employers and employees must both receive the same amount of notice. The service contract stipulates that such notice be given in writing. 4 weeks notice is necessary if the employee has been worked for less than 2 years. 6 weeks notice is for 2 to less than 5 years. If the employee has been employed for more than 5 years, that must be 8 weeks notice. Because the claimant has been worked for the company more than 5 years, the notice period should be 8 weeks. But it was not. As a result, the corporation will compensate the claimants fairly for a wrongful termination. Next, according to the case, the company threatened the claimants with violence if she didn't accept the termination. VSS are recommend to the claimant. If she refused, the claimant would be fired without pay and would not be hired for another 3 months. But in the end, the company also didn't provide the 3 months for her. When the corporation announced the termination, it put the claimant under duress and forced her to terminate. As a result, the claimants decide to use VSS is not voluntary. Rather than forcing employee to pick VSS allowed them to depart on their own terms and given terminations letters and layoff benefits. If she refused to enroll in the VSS plan, she will lose her benefits and will be fired by the firm. The claimants accused that she was not allowed to leave the meeting room due to the persistence of the day and have no time to assist whether or to accept this proposal. The claimant chose to sign the VSS proposal after being threatened with violence. The claimants have no alternative options in the termination action. The corporations terminate the claimants in this manner, causing her abuse and shame. As a result, the corporation made a mistake in this case by refusing to negotiate with the employees and instead of threatening them with violence to force them to accept VSS. Next, in this case, the company knew that the reorganization plan before 2001, but they didn't disclose the relevant personnel, instead forcing them to choose VSS. The company claimed that the claimant was notified for her layouts, but the claimant maintained that she was only notified when she was summarized into the IT conference room. Despite the fact termination did not provide an explanation for why the company did not supply service to the claimants. There was also no evidence that the company had attempted retaining and transfer the claimants to different departments. Furthermore, there was no evidence that the claimant has given advance notice for her layoff so that she may locate alternative employment. This case can refer to Joseph Lim vs. Dr. Sandram Bahas. As a result, the court determined that layoffs were unjustified and that dismissal was not justified. Next, we are going to give some recommendation to the company. The recommendation to the company is provide T&D, training and development. According to the case, when the claimant heard that her department has been outsourced and she has been fired, the corporation have no evidence that she had received the required training and development. Training and development allows the organization to create opportunity of corresponding employees and enhance their talents, investigate additional skills and abilities, and subsequently transfer personnel to another departments to prevent termination due to surplus. Before termination, the company's training plans might be updated to meet the demands of the employees in order to achieve their job objective. After confirming the employee's ability to be promoted, implement the course according to the identified training needs, the organizations can select appropriate course and identify the training objective, course distributions, training hours, and implementation time. Because the company is experiencing a personnel surplus, the organization should develop a training budget based on the identified training costs and the current market situation. Finally, the organization should encourage employee career growth by providing opportunity for employees to improve their personnel abilities, receive training and development, and have a platform to showcase their talents and knowledge, as well as personal advancement and development. The recommendations to the companies is terminate employees with notice. This is to avoid the similar incidents in the future. The company should issue warnings to employees and provide a notice period to termination. According to the case, the defendant's corporation fails to inform the claimants that she would be terminated before terminating her. Furthermore, there is no matching notice period for employees after a termination proposal is made. Before deciding on outsourcing, the company should notify relevant employees that they will be terminated so that they have enough time to find a better job, or the company can implement appropriate training and development plans. The relevant termination notice periods must schedule in accordance with the Section 12 of the Employment Act. Next, the recommendation to the company is communicate with employees. In this instance, the best as to is to allow the organization to communicate efficiently and to negotiate with the relevant personnel before or during the termination. If the employers and employees reach an agreement and sign the work contract after terminating, the employer and employees can freely agree and sign the VSS contract. When employers and employees are still talking about the VSS, it isn't considered unfair dismissal. Whether VSS is legally enforceable contract, if VSS is found to be lawful and effectively, it will end the employment relationship between the parties and will not be considered termination. It can be proved that this termination is legitimate if there is a clear communication and understanding of VSS between employees and the employer, and evidence that employees will not pressure, seduce, and threaten with violence when they sign the VSS. The last recommendation is the company to help the employees to connect with the next company. Employees can be connected to outsourcing firms, and employees can be introduced to outsourcing companies. The outsourcing is relevant departments by the corporation is attributed not only the poor performance of the relevant departments employee, but also to economics relations. As a result, the company can offer the best termination scheme for outsourced departments employees, namely negotiating with the outsourcing companies and allowing the outsourcing company to consider present employees, because the current staff have a good understanding of the associate work. The outsourcing firm will be able to enter the organization more quickly. This can also ensure that people who have been fired have a job to compete in a short period of time. That's all for my presentation today. Thank you for listening to me.